the history of the CTP scheme, in 1942 there was the introduction of the Motor Vehicles Third Party Insurance Act, and it was the first personal injury insurance scheme in New South Wales. Before this act, all personal injuries entitlements in New South Wales were determined by common law, whereby the person at fault for the accident wouldn't have to pay damages to the person or the accident victims effectively. The concern in that regards was that if you were the victim of an accident and the person that was at fault for the accident didn't have any financial resources at all, then the injured party would effectively go without any compensation whatsoever. So after World War II, cars became a lot more prevalent and there were a lot more people on the road and people were driving greater distances, which just led to an increase in accidents, unfortunately. And as a result of that, there was a 370% growth in policies with regards to CTP claims. In the early 1950s, the media focused on the disparity between personal injuries or compensation that arose out of the workers' compensation scheme and the motor vehicle scheme. Funnily enough, since almost as what's been forecast in the changes to legislation recently, so the 2016 reforms, it's looking like it'll be the first time whereby workers' compensation entitlements and compulsory third-party motor accident entitlements will be uniform. But the way they've done that is effectively slash benefits to everyone. Early in the mid-1960s, the scheme was reformed by removing juries and having matters heard before judges, because obviously juries were giving too high of a reward considered by the Insurance Council. 1970s, compulsory personal injury insurance was back on the political agenda due to high inflation and significant increased costs of premiums. And in 1984, the first legislative attempt to directly limit claim costs, including limits on damages, was made under the Motor Vehicles Third Party Insurance Act 1984. Transcover was introduced. It was a fault-based scheme introduced in 1987, administered by GIO, or the Government Insurance Office. It was a radical departure from previous common law schemes as it set statutory benefits. It was very unpopular, and it looks like we're heading back towards those schemes. The Green Slip scheme at the moment, Motor Accident Act 1988 restored the right to bring common law claims, but it introduced some restrictions. So over this whole period of time, we've been eroding away people's common law rights. The Act also opened the market to private insurers, which is quite difficult. And I know we'll talk about corporatisation of private health insurers. Also, motor vehicle insurers or private insurers has been a big factor. What we're up against effectively from a state-based is a very, very strong lobbying group. The insurance companies are in CTP insurance to effectively turn a profit. And as a result of that, the only way they're going to turn profit is to ensure that they keep their claims costs down. The scheme today, the Motor Accidents Compensation Act 1999, came into force on 5 October 1999. It promoted competition among CTP premiums. Reforms were designed to encourage early and appropriate treatment and rehabilitation for those injured in a motor vehicle accident. The Act made more appropriate provisions for the future needs of those with ongoing disability and encouraged the early resolution of claims. There have been a number of enhancements to the scheme since the introduction of the MA's Motor Accidents Compensation Act, which provide greater access to benefits for injured people. Some of the main features of the scheme I can go through. These are quite ironic because the whole purpose of the legislation was set up for these particular purposes, but the insurance companies, in my view, we deal with claims every day, and we've been dealing with sort of in New South Wales alone about 4,000 claims a year. Almost the conduct of the insurers and the duty of the insurers is completely opposite to what they've engaged in with regards to this legislation. So the whole purpose of the Act was to encourage early resolution. Claims must be made within 6 months of the date. The Motor Accident Compensation Act imposes a duty on insurers to make a timely offer of settlement if recovery is sufficient to allow the claim to be quantified, so for us to be able to put a value on the claim, and the claimant provided all relevant particulars, and if the matter cannot be resolved between the parties, to refer it to CARS, which is the Conciliation and Assessment Resolution Service. I'm sure there was all pun intended in that regards with regards to motor vehicle accidents, and the Alternate Dispute Resolution Service, so CARS would effectively decide on people's entitlements once they're injury stabilised. The addition of MAS, which is the Medical Assessment Service, so it was an independent assessment of treatment, rehabilitation and care needs, similar to what Dr. Chesterfield-Evans was saying. The purpose of MAS was to determine all medical treatment duties of an insurer, to make hospital, medical and other payments, and degree of an injured person's permanent impairment. Assessment was by medical experts and other healthcare professionals who have been appointed because of these particular fields of expertise. What I'd like to discuss effectively is your entitlement to treatment in the insurance sector, whether it be by way of CTP scheme or effectively by way of workers' compensation. The entitlement, if anyone suffers an injury, whether it be at work or as the result of a motor vehicle claim, you should be entitled to what's considered reasonable and necessary medical treatment. Unfortunately, with the attitude of certain insurers, and as Dr. Chesterfield was saying, there's certain intervening factors which cause some concern for respective patients. When we see clients come across our office or sitting across our table, they come to us with genuine concern for the payment of their rehabilitation and medical expenses. They're not thinking about big compensation claims, they're thinking about their health and well-being, the future of their families, the future of themselves. And when we're saying to them, unfortunately, the insurance company has refused the payment of your reasonable and necessary medical treatment, and this is treatment the likes of the good doctor would have recommended as reasonable, which could be an X-ray or it could be a CT scan or an MRI scan, purely for the fact that they don't believe that they think it's reasonable or necessary. When I say they, I'm not talking about a doctor, I'm talking about a 20, 25-year-old claims officer or 30-year-old claims officer who has taken upon themselves to be the judge, jury and executioner for a particular claim at first instance. The thing that gives me even more concern is when the insurance companies refuse to pay for your treatment expenses. Some of them have the gall at the end of the claim when we're trying to decide it in front of a judge or an adjudicator of fact to turn around and say, but this person didn't mitigate their loss. When I mean by mitigate their loss is this person didn't go off and get the required treatment that they needed to get better, when in actual fact the insurance company was refusing to pay for that treatment that they needed to actually get better. My concern with regards to the current reform, so the New South Wales state government has tabled or put out a statement effectively proposing CTP reform. And what they're doing is effectively placing all their faith and all their confidence in insurers to effectively make decisions around people's entitlements to medical and treatment expenses and claims entitlements. And insurers will take any opportunity to reject a claim. And what I wanted to do was basically to give you some stories about certain clients that I've had to deal with on a day-to-day basis. And I think it's one thing to go through legislative schemes, but if you're dealing with actual people, then you'll appreciate what people are faced with. So I had a client, Joe did say I used to do work for insurers, and it was a pretty difficult part of my life because I enjoyed doing work for plaintiffs. So our firm prides ourselves on sticking up for the little guy. And it was one of the first times where one of the first clients I had seen since stopping work for the insurers and working for mums and dads. And I had this gentleman in front of me, I can't name names. He was a young, robust 64-year-old gentleman who was doing quite heavy labour-intensive work. And similar to many people, I don't want to stereotype the age, he's had a couple of ailments along his way, so his body's not ideal. He's had some previous back surgeries. As a result of an incident that happened at work, he injured one of the discs in his back. And he was first assessed by the workers' compensation insurer and the doctor, and he went along to his own GP, and his GP said, look, yeah, you need some private treatment or some specialist treatment, and he was referred on to an orthopaedic specialist who was quite an authority on lumbar surgery, a neurosurgeon in Brisbane this was. And the surgeon said, yeah, you need there's a new radical procedure with regards to this particular type of surgery. And the insurer was playing game all the way through until such time as the specialist recommended that he have this surgery. So they initially approved the surgery, and he was earmarked to go to hospital 2 weeks later. So he was in a private hospital and awaiting his surgery. He was ready, prepped to go for surgery, 8 o'clock that morning. 7 o'clock that morning comes a phone call from the insurance company saying we're denying the surgery. Purely for the fact that, and this gentleman purely for the fact that he had a pre-existing back injury to a different disc within his spine. They were saying it was an aggravation of that previous injury. Had nothing to do with that same part of the surgery. So effectively this gentleman was told to go home, get dressed, go home, you're not having the surgery, and left pretty much to his own devices. He was in my practice saying to me, the thing that knocked me for six was he was in my practice saying to me, I've had a discussion with my wife about finishing my life. I want you to move on. I can't deal with the pain. They've given me medication to pretty much dope me to the eyeballs. I'm a zombie. I can't operate. I can't function. All he wanted to do was go to work. So we devised a plan and a strategy to get him his medical expenses, or to resolve the claim effectively, because it would have taken us, ironically, just as much time to run the claim and complete the claim as it would have just to argue the toss on whether he should and should not get the surgery. So in that instance, it was just better to run the claim and finish it. I know it was a difficult circumstance. It has a happy ending. So we managed to get him the result that he required. And all he said to me at the time was, I want to go back to work. If I can't go back to work, my life's not worth living. And he was 64 years of age. And ironically, we got him his compensation. He paid for his surgery the next day, and he was back at work 2 weeks later. Now, if the main purpose of the legislation is rehabilitation and getting people back to work, that would have been the perfect example of doing that. But the insurance company looked at the cost affiliated with the surgery, looked at the ongoing cost affiliated with his rehabilitation, and refused him treatment on that basis alone. So when I get serious concerns when the state government come on, and in particular the main politician, Victor Dominello, was on ABC yesterday, spruiking these reforms, effectively saying that we're concerned about low impact injuries and people who exaggerate their claims. Now, the question I have, I suppose, for the government is, what's an exaggerated patient? We've got checks and balances all the way through to ensure that people that do exaggerate or do embellish are dealt with. Doctors will diagnose them as being embellishers, and doctors will also address them, and the insurance companies are entitled to get opinions on their injuries as well. What I can tell you in no uncertain terms, and the government will paint the picture, that almost anyone who brings a claim for compensation is an embellisher or is an exaggerator of their symptoms. In my practice, I've probably had 1 to 2% of patients that would probably fit into that mould. I don't see any sane person wanting to go through the whole process of a compensation claim purely just to get a compensation at the end of the day. They wouldn't subject themselves to the invasion of privacy and to the intrusion. And now for the state government to turn around and say that any of the majority of patients that would embark on a CTP claim or a work habit claim are exaggerators, I think it's a bit of an insult, or actually more than a bit of an insult, to the New South Wales residents of this state. In addition to that, what we have is a very significant insurance lobby. So behind the scenes, the insurance companies are lobbying the government for defined statutory benefits, which effectively means that moving to a no-fault scheme. So in New South Wales currently, if you want to recover for CTP or compulsory third-party motor vehicle damages, someone needs to be at fault. Now the government's saying, well, that's fine, we can actually remove that element of negligence and give everyone who's entitled, or everyone who's involved in an accident, opportunity to get some sort of benefit. When you open up benefits to everyone, what it effectively means is those who are the victims of an accident, and the government's rationale behind that is no one gets behind the wheel with the intention of causing an accident, and I would agree with that. But if you've got tens of thousands of people who unfortunately get caught drink driving every day, and ironically we're in a pub having this conversation, so be safe when you go home and don't drive, and get a cab if necessary. But if you've got tens of thousands of people a year statistically getting behind the wheel driving, none of them get behind the wheel with the intention of hurting anyone, but they're still breaking the law when they get behind the wheel. If you've got someone who unfortunately was texting on their mobile phone, looking at a text, and drives head-on, has a head-on collision with an oncoming vehicle, that person who's now texting has the exact same rights and entitlements as the victim of that opposite car. Now, the only way they can do that is by slashing the benefits of the victim of that accident. Now, in my view, that's not fair. We were all for reform, but reform without people losing the entitlement to sue for their fair and equitable compensation. Now, the government's spruiking it as a reduction in premiums. Now, when it was put to the insurance company, now in 1999, the legislation was introduced, and the purpose of that, and it was actually legislated that the insurance companies would only retain 8% profits. Year on year since the introduction of that legislation, they've been scraping about 19% profits, so twice as much. And the government has consistently had dialogue with the insurance companies and said, 19% profits, what's going on? You promised an 8% profit margin. And their response is, the unpredictability of claims. We can't predict what claims and processes are like. And as a result, they've justified that for their own means of taking, open inverted commas, super profits. So the whole purpose of this 2016 reform is so the insurance companies will pretty much administrate the whole CTP scheme and moderate their own backyard. And as a result, they've promised the government that they'll no longer take super profits. But when it was actually put to the Insurance Council today, or the last few days, can you guarantee that premiums will come down as a result of these CTP reforms? The answer was no. So even though we're slashing benefits, effectively we're still not getting any more rights. We're actually losing rights as a result. One of the other things, just another example of insurance company behaviour, and I get a bit frustrated about this whole process because what we're trying to do is achieve a just and expeditious resolution of our clients' cases. In CTP schemes and in CTP legislation, if you're involved in a motor vehicle accident, you've got to fill out a personal injury claim form. And as a part of that claim form, it has circumstances around the accident, circumstances around who was involved, who was at fault, draw a diagram. And you're obligated to get a medical certificate from your GP. And your GP will list the nature of the injuries you sustain as a result of the accident. And it's a requisite of the Act. You have to provide it on a prescribed form. And you send that into the insurance company. And that's the first official record of you being involved in an accident, so to speak, or you're making a claim. You send that into the insurance company, and the insurance company's got an obligation to provide reasonable medical expenses. Now, we've had instances where insurance companies have rejected people's medical treatment just off the back of that form. Now, insurance companies have got no idea as to the level of impairment that particular individual has suffered as a result. They've just taken the GP's record and said, this person's injuries aren't related to the accident. Now, how they form that opinion without any doctor examining this patient is unbelievable as far as I'm concerned. What I am concerned about is the government effectively making a statement with regards to proposed reform to say that they can trust the insurance companies enough to take care of our health and adjudicate on our health. But in addition to that, they're trying to eliminate lawyers from the whole process. They're effectively suggesting, so as a part of the workers' compensation reform, they tried to get lawyers out of the process, and as a result of that, and if you speak to many unions around the traps, when someone sustains an injury at work, it's effectively their livelihood at stake. And as a result of some reform and people being cut off benefits, there were a number of suicides that occurred. I'm not over-dramatising it, it's exactly what happened. And as a result, the government introduced that legislation, but they tried to get lawyers out of the equation, but realised that they were required for a particular purpose of preserving people's rights. They developed the Workers' Independent Review Office, known as WIRO. With regards to the C2P scheme, they're actually not even going to do that. The government said we'll set up some sort of advocacy and support group akin to conveyances with no legal standing, governed by the government, and effectively it'll turn all doctors into advocates and rehabilitation providers. So you'll have no one there really pursuing your rights other than your GP trying to argue for your treatment and expenses through the process. So to say that we have genuine concern about the 2006 proposals for reform, we do, because it affects us quite significantly, and a lot of the time injured patients won't even necessarily have the rights to make a claim or the right to any legal advice when their claims or their rights and entitlements are being eroded. or they can't be pursued as a result of insurance company decisions. The actual right for a review, if you're concerned about a decision from the insurance company, is to go back to the insurance company and ask them to review it. And as I've said to the good doctor, it's like going to your mother-in-law about your wife, which isn't going to be too great. Considering my wife's in the back of the room, I shouldn't have said that either. But that's all I've got to say on that topic. Thank you.